Mediations YouTube series, Access to Justice, where each month critical discussions related to alternative dispute resolution, ADR, will be facilitated and solutions to challenges in the field fostered. This series also aims to educate you, the viewers, about alternative justice for you to be more knowledgeable about the use of ADR in resolving disputes. Today's topic zooms in on a highly talked about subject matter, one that casts Jamaica's justice system in a positive light due to its wise and extensive use of mediation, but also raises concerns as to how dispute resolving method is being used. Before going any further, however, I encourage you to support the channel by hitting that subscription button and clicking the notification bell. Also, like, share, and comment on the video below. The highly anticipated topic for today is Parish Court Mediations, Mediators versus Probation Officers. This topic explores a much questioned and talked about observation. Probation officers conducting mediations without prior training. Let's now turn over to guest host Mr. André Earle and panelists Miss Deneve Barnett and Mrs. Deneve Hobson-Hector. Also adding their voices to this conversation are ADR practitioners Mr. Clayton Parchment and Mr. Burchell James.
Thank you.
All right, so we're going to be discussing this whole matter, and perhaps a good place to start the discussion is just to explain for the viewers what really is the role of the probation officer and what is the role of the mediator.
One thing that the probation officer does, and that is to help the judge with sentencing. So if one is found guilty in the parish court or in the circuit court, the judge often asks for a social inquiry report, and the probation officer will interview the victim, the offender, and other members of the community to assist the judge in coming to, let's say, an appropriate sentence or punishment. They are trained to make recommendations. The mediator, on the other hand, is aware that he or she has no sides. He or she does not know what is the best solution. The mediator listens to them, the parties, and allows them to make their own decision and resolution.
Mediator knows I must get the information I need from each party, and I must encourage them to communicate with each other so that what is agreed is a final settlement and everybody can work with it.
So Deneve, I'm a little man. I go before the mediator against a man that have whole heap of money.
Yes.
I don't have the education level that he has or she has. And I don't speak as well, as articulately as he or she does.
Yes.
Does the mediator seek to compensate somehow for that power or that perceived imbalance in the room?
The mediator mediates. He puts them on the same level as best as he or she can. So it may be that you have to translate some patois to English or some English to patois, but what is important is that both parties do communicate. The mediator encourages each party to listen to the other party's side. So with proper communication and proper listening, invariably there's an agreement, but though the mediator intervenes in leveling the playing field, it is not in a way that is advantageous to any one party over the other.
All right, so I can feel confident then, as a little man in the mediation, that the mediator is not going to favor the big man over me just because he have more money than me.
You can feel confident of that.
Okay, so thank you very much for that, Deneve. So perhaps, viewers, it would be an opportune time then for us to define mediation for you. So Jennifer, what is mediation?
Okay, mediation starts where there's a dispute. Okay, so 2 or 3 sides will need to come together, understand what are the difficulties, and get guidance as to what processes can be done to settle that issue. Persons who are part of the dispute do have an opportunity to make some suggestions as to how they think it could be dealt with.
I think is important is for persons to understand that there's a difference between counseling and mediation. Sometimes people go for mediation and what they get is really counseling, when really mediation would have been a very good sister to the counseling.
So what's the distinction between the two?
Well, I think in counseling, I can't really tell you the distinction, but from a scientific point of view, but in my opinion, in a counseling situation, the counselor is giving the parties what they think is the best solution and what is morally right and what is financially right and so on, which is different from the mediator who listens to them, the parties, and allows them to make their own decision and resolution, because at the end of the day they do usually have to live with each other.
So the mediator really is acting then as a facilitator.
The mediator is acting as a facilitator.
And coordinating the negotiations between the two disputing sides, the two or more disputing sides, with a view to arriving at a settlement.
Yes.
How is that settlement reflected? Is it that the disputants just shake hands and walk away? Is it recorded in a document? And how important, if it is that it is recorded in a document, how important is it?
Well, the mediation done by the DRF is usually recorded on a document that the parties sign to, agreeing that this is the way we go forward. The parties say what the terms are, the mediator writes the terms, reads back the terms to the parties, finds out whether this is what you agreed to do or not to do, and once that is done, the parties sign to it.
All right, thank you for that. And Deneve, what kind of time frame we're talking about? Is the mediation process over days, weeks, months, hours? What is it?
When the probation officer does from my observation, when a probation officer does a mediation in the parish court, it is usually done on the spot, same day. And I'm not blaming the probation officers, it's the time that they're given. Often it is expected that the mediation by the probation officer will take place on that particular day in a short time. But we are aware that a proper mediation takes probably 2 hours minimum. If you go to the parish court and you refer to the Dispute Resolution Foundation, you obviously have time to compose yourself, go to the meeting, and the time is not as limited as when you're at court. And the probation officer is almost racing to have a resolution before the court is done for the day. And then in addition to that, the probation officer is aware that he or she might be needed in court for other matters, other similar matters for mediation. And so for that reason, I think that their resources in terms of time is stretched. And for that reason, I think that the Dispute Resolution Foundation does play a very important role in mediation. If these services were more widely used, I think that the work of the courts would be reduced and the parties to the disputes, be they criminal or civil, would be more satisfied in that they would feel as if they have assisted in coming to a resolution satisfactory to them, or all of them. They do a lot of work. Problem though is that, to my mind, they are overworked. That is probably not their main remit of their job. And so at the parish court, when a probation officer does a mediation, I don't know that they get sufficient time to allow for a proper mediation process.
Following from what Deneve just said, Jennifer, in terms of the mediator, what are some of the critical skill sets that he or she should have?
Okay, so she has to be a listener, or he. If you're not able to listen to other people speaking, because some people have a difficulty with that, you know. They think that people must listen to them. they don't understand that it's equally important for them to listen.
And that active listening is itself a skill.
That is a skill, and that's a major skill for mediation. Because remember now, you're going to have a number of persons before you, and they all want to speak at the same time. So you have to control that. You have to therefore have patience.
All right.
Those two I consider very important.
And confidentiality is also an important one, I imagine.
So important, because if the mediators ever seen or people think that that person is going to be repeating something that is said in that mediation, the confidentiality would have a problem there. So anybody who's doing a mediation knows that confidentiality is important.
So as one of the parties to the dispute, I would have the confidence of knowing that this process is going to remain confidential. Nobody is going to repeat my darkest secret outside of the room, and I can know that I can speak candidly and openly and freely. That I imagine that must be one of the aims, the objectives behind the whole confidentiality of the process.
But importantly too, at the Dispute Resolution Foundation Mediations, before the mediation begins, the mediator outlines the fact that he's neutral or she's neutral, and he or she's usually big on the issue of confidentiality. So the parties understand that if we come to mediation and we don't come to any agreement and we have to go back to court for the case to be tried, the judge or no other party in the court hears what happened in the mediation process, why it did not work, what would have made it work. They go back to court, and nothing that was disclosed in mediation is put before the court or any party that is in the court. So because of that issue of impartiality, and the parties are aware of that, they are usually more open in the mediation process. And I find that the more open the parties are, the easier it is for the dispute to be resolved.
All right, thanks for that, Deneve. Back to you, Jennifer. In terms of the probation officers, Deneve just mentioned that they are handy, so the court can just lay hands on them suddenly and ask for assistance in the dispute resolution process by way of mediation. But really and truly, in the absence of training, how effective is this mediation that the probation officers are undertaking?
I'm of the view that the training is important for the probation officers. So they do have skills and
That's a mediation training.
Yes, they do have skills and training before in the field that they're in. However, now we're wanting to include them in mediation. They therefore must be trained in mediation.
Where a mediator is trained to be patient and to allow the parties to come to their own resolution as best as they can.
And to listen.
And to listen, and not to, and to consciously try not to superimpose your values on the parties. I'm not sure if the probation officers are trained in that way to make those conscious decisions.
All right. So bearing in mind what you said about the timing and the probation officers having such a heavy workload and hence less time to conduct individual mediations, what are some of the other pitfalls that await probation officers who are in the process of doing mediations? And I'll ask both of you to jump in as you see fit.
I have heard a complaint that up to yesterday, in fact, parties went to a probation officer mediation, and one party came back and said that the other party wasn't listening. The truth of it all, as I said, is that it was an on-the-spot mediation. So with the best intent of the probation officer, if one person overspeaks the other, there's very little time for the probation officer to moderate the time or to give the other party equal time, because they're aware that their time is limited. Sometimes the poor probation officer really does not have before him and her all the parties who are party to the dispute, because sometimes disputes start from small things and build up to something violent, so somebody ends up in court for assault, OB harm, or wounding, the dispute didn't start on the day that the wounding or the assault took place. It probably was a build-up before this. When the parties go to court, the victim is there, the accused is there, the person who said something that caused a dispute is not there. And so that is the drawback that the probation officer has with the on-the-spot mediation. When it is not on the spot, they would be able to listen to both sides and realize that, but hold on there, there's another person who I need to hear from, who can probably, or who the parties need to hear from, who can probably assist in resolving this dispute. So that is another disadvantage of the on-the-spot mediation. If it is that the mediation commences, the probation officer probably doesn't have the facility at his or her office or back to time to allow the parties to come there for part 2 of the process, whereas the Dispute Resolution Foundation has that facility for parts 1, 2, and 3, or however many required, for the dispute to be resolved in a manner that is acceptable to all the parties. So those are the 2 main pitfalls. I don't want to go into whether or not the probation officer imposes her view, because I really can't say that for sure. I just suspect that because subconsciously they're required to put an opinion all the time, they may be doing so without even realizing it.
Okay, so thank you very much for that, Deneve. So
when the probation officer does a mediation, the parties may well think, unless they are properly told, they may well think that the probation officer has a duty to go back to the court and say the parties agreed to this because A and B, or did not agree because A and B and C. So with the Dispute Resolution Foundation's mediation, we are quite sure that the parties are made aware that the mediator is impartial and is neutral, and that the information being disclosed there by either party is absolutely confidential.
Greetings, I'm Clayton J. Parchment, a mediator in the Parish of Westmoreland and the founder and operator of the Westmoreland ADR Center. I'm here to share a brief note with you on the topic of mediators versus probation officers in assisting you in resolving your disputes. Mediation is something that is offered at all levels in our society, community level, the court level, from the parish to the Supreme Court, and any other areas that one may see fit to resolve disputes, commercial or otherwise. Mediators are effectively trained through the Dispute Resolution Foundation in Jamaica, and they also, by the way, offer services to the wider Caribbean. They train their mediators effectively and capacitate them with the necessities to effectively guide disputants to a common ground, a clearer understanding of their differences, and to see how best they can amicably resolve the differences and bring harmony once again. Probation officers are required to fulfill a wide gamut of duties that may not allow them the time that is required to devote to your particular matter. Mediators are expected to effectively carry a matter to a resolution that is final and under no circumstances can be found wanting through scrutiny. Probation officers have been excused and given the permission to conduct mediations in the past and possibly will do so in the future. The question one has to ask: what is the value of what they're receiving? Is it that I'm being rushed to a resolution, or is it that I'm being guided safely to one that in future, when the circumstances that have caused the first dispute come up, I'm able to resolve it or nip it in the bud before it gets any further? These are some considerations one would have to make in making a choice or making a decision as to how best to resolve their disputes. In our culture in Jamaica, we have what we call the community lawyers, persons who seek to exert influence or incite some form of information upon a dispute, or in quote-unquote terms, buy out the argument. These are persons that we ought to be very careful of, and a greater respect ought to be given to the justice system, and not to take matters in our own hands, but to move respectively to the various agencies, areas, or organizations to guide us properly in resolving our disputes. Let us make the right decision as to how best to treat our differences, and if we have somehow fallen in the worst case scenario, let us make the right decision at the court level by choosing the right mediator to resolve your dispute. The DRF has a wide network across the island. Call them and see how best they can assist you. All the best, and let's make Jamaica a peaceful place to live.
Good morning. My name is Burchell James. I'm a mediator, a trainer and coach, and also president of the Jamaica Association of Mediators. I'd like to address this morning the issue of mediation in the parish courts, the matter of mediators versus probation officers. There is no doubt that the use of probation officers in the courts provides some advantages. These include speedy settlement, a reduction in the courts list, and it being free to the parties. However, we need to also look at the disadvantages. But before doing that, I want us to look at what really is mediation. And generally, mediation is voluntary. All the parties are allowed to speak. All issues are examined. Usually, the underlying issues are found because the presented issue is not always the real cause of the conflict. And thirdly, there is no pressure. Fourthly, it's the will of the parties, a general consensus that is arrived at. So let us look at the disadvantages of probation officers conducting on-the-spot mediation, which is really what happens when the judge refers a matter to the probation officers. One, the probation officer is trained and experienced to do a particular job. And two, the probation officer is asked to settle the matter or have the matter settled within a certain time frame, usually less than an hour. And the probation officer carries with her or him the authority of the court and their own position and their own knowledge of the situation. And so we end up with the matter being settled, but the parties being dissatisfied, or at least some of the parties being dissatisfied. And in many cases, we find that the same parties come back to court, either for the same issue or for other issues that emanate from the dissatisfaction that resulted in the on-the-spot mediation. There's also the issue of the parties not being able to explore the real cause of their conflict. And so what is needed is a recognition that mediation cannot be done under pressure. A time limit cannot be imposed on it. And proper mediation provides for long-term resolution of matters. In the short term, the court list will be reduced, but it's going to increase again because the parties will come back. And unfortunately, in some instances, the party take matters in their own hands. And so instead of resolving a conflict, we escalate the conflict. Therefore, today's session is very important Because as the ministry seeks to address the issues, which include the court list, but more importantly, a reduction in dispute in the communities, I think we need to examine what are the ways to resolve our own conflict, our own dilemma of increased conflict in our community and people resorting to violence. So I look forward to our discussions. Thank you.
I'm going to give you both an opportunity just to give a closing comment.
A family matter can be dealt with without a gun. So we really have to continue to do what we're trying to do now. Get the DRF training spread to more than just the attorneys.
Yes.
Or those other people.
So making the public aware first that this training is available,
yes.
and that there are ways to resolve disputes, especially domestic disputes,
yes.
in these sorts of ways, mediation,
yes.
and that's what you would want to promote today.
I would do that, yes.
Yes. Deneve, your closing comment?
My closing comment is that as a nation, we really ought to listen more, care more. When there's a dispute, if you find that it is beyond you, try to seek help. There are justices of the peace in the community, teachers, pastors, persons who work at the court's office in the community, police officers, regular persons who you know will give sound advice and who will listen. And there are persons who know where to direct you. Maybe I can't assist you, but I can say, go to the court's office. The court's office may say, okay then, based on what you're saying, you want a dispute to be resolved, go to the Justice Center or go to the Dispute Resolution Foundation. It is important that we slow down our thoughts and try to think about the next step. The minute we act immediately, it is, for me, the minute that you give a great opportunity to make a mistake.
Well, that's it for today's session, viewers. But before going, please allow me to convey sincere gratitude to my special guests for their invaluable input on the subject matter. And please, viewers, don't forget to subscribe to the channel and like, share, and leave a comment if you haven't already done so. Join us again next month for another engaging episode of Access to Justice, ATJ, brought to you by the Dispute Resolution Foundation. Remember, together we can work it out to make peace, increase, and create a society where justice is widely accessible, having and knowing no boundaries.
I bet you would agree that there is so much more left to explore. So join us for part 2 of this discussion. Thank you for watching.